All due respect, like I said, I don't have anything personal against this court. I'm not a corporation, right? I'm a natural person. Where is the body of the crime, Judge? You went to law school, you're a practitioner.
No, because I haven't heard testimony.
Welcome back to the channel, folks, and buckle up, because today's case is one of the wildest sovereign citizen meltdowns we've seen in a courtroom. This isn't just some guy rambling a few legal buzzwords. This defendant goes all in with constitutional misquotes, bizarre Supremacy Clause arguments, and claims he's not bound by the same rules as everyone else. But here's the kicker. All of this chaos stems from something as simple as him not wanting to carry a driver's license. You'll see him challenge the court's authority, accuse prosecutors of conspiracy, and even try to flip the tables on the very people bringing charges against him. What makes this case so fascinating isn't just the nonsense. It's how the judge handles it. Calm, collected, and unshaken. The judge dismantles his arguments one by one while keeping the case on track. As you watch, pay attention to the subtle shifts. Every time the defendant thinks he's scoring points, he's actually digging himself deeper. So stick around, because by the end, you'll understand exactly why sovereign citizens never win, no matter how loudly they shout.
Anything personal against this court or anything, I just request that this court adhere to the Supremacy Clause of the U.S. Constitution and hold that these state statutes in which they have me charged with are constitutional based on the U.S. Supreme Court. And what is the case? The Shaney versus Winnebago Department of Social Services, there was a young child whom the mother relays that the father was beating the child and the child died. The mother sued all the way to the U.S. Supreme Court. And the U.S. Supreme Court held that no matter how bad or gruesome that this case was, when it concerned the case, that the states have no duty to protect citizens from other citizens. Anything that compels performance, there has to be a contract. And again, I reserve my rights under UCC 1-308 and the common law UCC 1-103.6. And it's clear, Your Honor. And I ask that this court, do their sworn fulfill their sworn oath under the Michigan rules, the Michigan Judicial Code of Conduct. The court is not to be swayed by public opinion or what the people may think or whatever it may be. Like the great honorable Judge Dalton A. Robeson. So every government is entitled to a Republican form of government, not a corporate. I'm not a corporation, right? I'm a natural person. The case law clearly breaks everything down, which everyone is in default. I just ask that this court dismiss this case at this juncture. If the court does not, I demand under the Supremacy Clause, the subpoena power of this court, to have Ken Worthy brought in so we can have an evidentiary hearing. Because how can a criminal prosecute or allege that I'm a criminal when they're committing all the crimes, Judge? Since I've been home, I've been making reports of police and other things, violations of law against me at the precinct. And no one listens to me. They just ignore me. But when people call and say, well, hey, Mr. McCreary did this, Mr. McCreary did that, they come, then it's found out nothing happened.
Under our state constitution, this court has jurisdiction. Furthermore, as far as discovery goes, I personally sent Mr. McCreary twice, and I have the emails, copies of the emails to show it if that's necessary.
What are the dates?
Dates are not on here. May 24th, which was last week, and May 5th.
And here it is, the classic sovereign citizen move, invoking the Uniform Commercial Code like it's some magical shield against criminal charges. Let's break this down. The UCC governs commercial transactions, things like sales, negotiable instruments, secure transactions, not criminal traffic cases. So when he says, I reserve my rights under UCC 1-308, it's basically meaningless here. It's like bringing Monopoly rules to a chess match. But this is a hallmark of sovereign citizen ideology, stringing together real legal terms in completely wrong contexts. My question to you, do you think he actually believes this works, or is it just an act to waste the court's time?
I'll give you, it's gonna take a couple seconds. One of those emails, he is Michigan.
in there.
That's not my fault. They violate your
Mr.
order.
McCurry, can I
Yes,
talk?
ma'am.
Okay. So you should have received one of them,
Nothing.
Right.
and neither one of them came back as a bad email.
Okay. All right, so Mr. McCurry, I don't know why you're not receiving discovery, you did not receive it?
He didn't send, can we subpoena Google and,
No,
litigate this and
This is
show that he
not,
hasn't
this
sent
is not a
anything?
trial, this is not evidence you're hearing.
Well, can I say one more thing?
After we get done today, we confirm your email address, you can even send a test email to make sure that he received it.
Well, he did. It showed me that he got my paperwork. He admitted in the last receipt that he received my
Okay,
paperwork.
and
So why would he send it? Well, not, why wouldn't I get it back? My email is legit. It's my phone right here.
okay,
Also a jurisdictional challenge,
let's,
right?
before we get to that, Adrian or Cecily, you want to respond before we create?
Yes, Your Honor, I do want to make a record. You know, this defendant has already availed himself to the jurisdiction of the courts of the state by admitting to having a driver's license. And also further add that the 10th Amendment has allotted and given police powers to the states, which then allows the states to create criminal laws under which.
This is one of those hilarious yet frustrating moments. The prosecutor says discovery was sent to him twice. The defendant insists he never got it. Now here's the thing. Emails don't just disappear into thin air. If he got discovery once before, it means the system worked. So why suddenly play dumb? This tactic is common in these cases. Sovereign citizens try to stall proceedings by denying basic facts. But notice his body language. The head shaking, the dismissive tone, its performance, pure and simple. He wants to look like a victim of the system, when in reality, he's just dodging accountability.
This defendant must avail himself to. I further add that, again, as the court has acknowledged, that this defendant has at least once received the discovery to his emails, to his correct email. So any more allegations of not receiving discovery would be improper, given that we have it at least proven that he has it at least once. And there have been no additions or corrections since the discovery was sent the first time.
Okay,
May I
Mr.
respond?
McCurry, I'm gonna wrap this up, you can respond and.
Yeah, just briefly if I may.
Sure.
Well, this young lady here to basically
Mr. Sessions,
respond, Mr. Sessions, to respond to her statements in Michigan. They're locking people up for not having a driver's license. I was compelled.
there are people getting
But I
locked up
reserve my
for
rights. This was the
murdering
law.
people as well.
Pardon?
People getting locked up for murder as well.
Well, I understand that, but what I'm saying is the corpus delicti, they're going off written statements. You know the corpus delicti rule under the Michigan Supreme Court case, as well as the federal court case. Where's the body of a crime? They're saying ammunition, all this, that. Where's the guns at? Where's the victim at? Strangulation, where's all this? Where's the medical
I wouldn't
reports?
know because we haven't
And
had
then,
an exam.
okay, but no, jurisdiction, once it's challenged, it must be proven by the people.
Ah yes, the infamous no victim, no crime line. Sovereign citizens love this phrase, but here's why it doesn't work. Not all crimes require a traditional victim. Driving without a license? That's a violation of state law. The victim is society itself because public safety is at risk. Think about it. If anyone could just hop in a car without training or regulation, the roads would be chaos. So when he demands to see a body or a victim, he's either misunderstanding the law or intentionally twisting it. What do you guys think, ignorance or manipulation?
Territorial jurisdiction. Even when I was in prison, I had interactions with Kim Worthy, chief prosecuting officer for the state, and I reserved my rights in prior proceedings, as well as I was compelled to obtain a driver's license, and I reserved my rights. That's all the law mandates, that I reserve my rights, which I have done. And right now, this lady, Mrs. Prosecutor, I can't remember her name, and Mrs. Sisson, Esquire Sisson, and this gentleman here, they're in conspiracy and violate federal and state law. They're committing crimes, and I demand that their oath of office, their law, their license to practice law, amongst other things, be given to me, as well as their bond, as well as you, Judge, Your Honor. Also, like I say, jurisdiction has been challenged, and they have to prove it first based on the case law, which I have noted in this paperwork. They can't get around that. We can say, well, yeah, they're talking about reserving rights and all that. Okay, but still the law from the state Supreme Court, Court of Appeals, and federal jurisdictions clearly mandates that once jurisdiction is challenged, the person asserting jurisdiction has to prove it. And all they have is statements. Under the corpus delicti rule, out of court statements is not evidence, so these charges should be dismissed. Where is the body of the crime, Judge? You went to law school, you're a practitioner.
I don't know because I haven't heard.
Here we go, the conspiracy card. Whenever the legal arguments start collapsing, sovereign citizens love to accuse everyone else of breaking the law. The prosecutors, the judge, even the clerks. It's a last-ditch effort to flip the script, but it never works. Notice how he demands their law licenses, their bonds, even their oaths. He's not arguing the actual charges anymore. He's trying to intimidate the courtroom. It's a classic deflection tactic. But here's the irony. The more he yells conspiracy, the more obvious it becomes that he's out of real defenses.
No.
Well, that's not how it works with jurisdiction.
That's how you don't that way. So, do you have any last?
Well, I would like.
Statements, because I made
Okay, I would like to challenge jurisdiction again, which I have done from the onset of this case. Personal, subject matter, and territorial jurisdiction. State and federal case law is clear, in which this court being inferior to the higher courts must adhere to their oath of office, their bond, and so on and so forth, their license to practice law, and the Michigan rules of Code of Judicial Conduct, and must compel the people to prove jurisdiction, which they're asserting. Where's the proof? You have to show this court. That's at any stage of the proceeding, the law allows that.
Okay. So on discovery, I saw paperwork confirming the email address that you provided to the court is now on the record, that discovery was sent. I'm not sure if it's an email, please don't interrupt. There's another email you would like to be sent to, I will ask the prosecutor to do so. 2, for requesting license numbers from everyone. My name is right here in front of you. You can go right on State
I
Bar.
ain't saying nothing.
RP numbers are available for you to look up as they are for any general public, okay? As far as venue, jurisdiction, and you mentioned this, you don't know whether I was appointed or elected.